Okay, I'm sorry. That was a hospital calling me.
It's okay, Mr. Brain. Who do you represent?
Well, I thought I'd put that out there. I represent the father, Mr. Robert Davis.
Okay.
I don't know if he's here. I can't see. Let me look. Survey says. No, I don't see him. Okay. Ready to proceed.
You know, I'm Mr. Davis is only being putative.
Well, let me see here.
Although I have you listed as his lawyer nonetheless.
Somehow or other, there must have been a reason at one point to do that. So I'm ready, if you are.
Okay.
Your Honor, is there a Megan Parsons in the waiting room from All Wellbeing Services?
There's nobody else in the waiting room.
Okay, thank you.
Everybody who's here is here. Mr. D'Ancimo, do you have video on your device?
I do, but it's not functioning for some reason. It was working at the last hearing I had last Friday. For some reason, it's not working today. I don't know what's going on. We had this problem before. Is it anything from your end, Your Honor? Were you able to mute or?
I can mute you. I can hear you fine, and that's good. I can mute and unmute you. I can't do anything about the visual. And there's a little sort of crudely drawn single lens reflex camera with a line through it indicating there's no video. Sounds like that usually only happens when it isn't available. It's not detecting it from the device itself. So you can do whatever, but I think we're ready to go forward with this today nonetheless then, if you are. Mr. D'Ancimo, your client is here. Are you ready to go forward now, or do you need a minute or two with her in the breakout room?
Forward, Your Honor.
Mr. D'Ancimo, I'm sorry, I didn't catch that. Did you?
I'm sorry. Can you hear me, Judge? Can you hear me okay?
I can hear you now, yeah.
Yeah, we're ready to go forward. I'm sorry.
Okay, great. Then if we are...
This meeting is being recorded.
Ready, we are on the record, calling case number 230000509 in the matter of Liberty Davis and Lauren Davis. Today is the date and time set for a dispositional review and a permanency planning hearing. I'm referee Dan McGuire. Could I have appearances for the record, please, starting with the Attorney General, Mr. A.E.
General Jeff A.E. on behalf of the agent Janice.
Good afternoon, Your Honor. Brenda Springs with the Michigan Children's Law Center, P00910. I'm the attorney for the minor children, Liberty and Lauren Davis.
Thank you. Can go quick.
Jeremy Brand for the father, Mr. Davis.
Thank you, Mr. D'Ancimo.
Leila Young, the mother of the children. Liberty and Lauren Davis.
Thank you. Ms. Young, could I have you unmute and give us your name for the record, ma'am?
Leela Young, the mother of Liberty and Lauren.
Thank you, ma'am. Ms. Young, do you have video on your device? Thank you. Go down here. Miss Latrice Williams.
Latrice Williams, I am the mother of Leela Young. Also, I'm the grandmother of the children Lauren and Liberty Davis.
Thank you. Miss Young, there's two great aunts, so Miss LaShawn Young, if I could have your name for the record, please, ma'am.
Name is LaShawn Young. I am aunt to Leela Young, great aunt to Lauren and Liberty Davis.
Thank you. Other than Miss Young, could I have your appearance,
Lisa
please?
Young, the aunt to Leela Young and the great aunt to Liberty and Lauren Davis.
Thank you. And Miss Sylvia Young.
Yes, I'm Sylvia Young, and I'm the great-grandmother of Liberty and Lauren Davis.
Okay. And are you the maternal great-grandmother or a paternal great-grandmother?
Paternal.
Paternal.
Maternal.
Okay. When when we were last in court in this matter, it was September the 11th, 2024. The court held a trial at that time and found that children came within the provisions of the Juvenile Code for the purpose of expediency to get services in place. All parties agreed to move forward with the disposition on that day. The court entered dispositional order set today as the dispositional review and a permanency planning hearing date. I am in receipt of a report that has been authored by Ms. Williams. Have all parties seen this report, and is there any objection to its admission into evidence?
No objection.
No objection, Your Honor.
There being no objection.
The report.
I'm sorry.
Yeah, I'm sorry. Judge, can you hear me?
Yes.
This is Andrew Densimo. I believe the author of the report is Wanda Dawkins, and we do object to the report because it is incomplete regarding the employment of Miss Young. We provided information to Ms. Dawkins regarding Ms. Young's employment, and the report should reflect that Ms. Young is employed full-time.
Mr. A, any response?
I believe there was a back and forth between Ms. Dawkins and Mr. Densimo regarding the employment aspect of the report. With her not being here, I know she's made efforts on her own to verify different employment. So when she wrote the report, she was not able to put that in the report.
Thank you. Mr. Densimo, Ms. Williams is a co-author, co-signer on the report. So I think as long as, especially since we have a co-signer who's here and eligible to be cross-examined, and your objection is noted, but to me it sounds more in line as a subject matter for cross-examination more than a question of admissibility. So I'm going to allow it in, but I'll allow you the full latitude on cross-examination.
What?
Okay, the report having been admitted with all noted objections, Ms. Williams, could you raise your right hand and be sworn, please? Ms. April Williams.
Yes.
Do you swear or affirm under the penalty of perjury that the testimony you are about to give before this court will be the truth?
Yes.
Thank you. Ms. Williams, I've read the report. You are the co-signator, correct?
Yes.
You're not the original author, or have? Okay.
Yes.
But you did read the report and are familiar with its contents.
Yes,
Thank
I
you.
am.
Are there any additions, deletions, or corrections to it?
Only thing Miss Wanda did report to me, whereas she received a call and she did get a copy of Leela Miss Young's ID, but that was basically it. But that was after she sent the court report in.
Okay. Is there anything you need me to order here today?
No.
Okay. There's a request in there about suspending mother's parenting time. Is that your position as well?
Yes.
Okay. I'll just leave that to the lawyers. And Mr. Agee?
Thank you. Ms. Williams, in particular, from your report, why is it that your agency is recommending the suspension of visits for Ms. Young at this time?
Because Miss Young still feels that there's no mental health issues, and she feels that she don't need any individual therapy or any medication, and we don't have no up-to-date information saying that she's getting services.
Okay. So from the report, it does indicate that mom is not very compliant with her services.
Correct, and that's with the mental health services. She has
And
finished.
that's
Yeah.
I was going to say, and that's the primary concern for this case.
Yes.
Okay. So at this, correct me if I'm wrong, but mom's prior visits have been. Well, let me ask this: what are mom's current visits?
Her visits are Zoom. I did supervise a couple of them in December, and they were on Zoom. A couple of them she canceled. Miss Dawkins also tried to take the kids to her job before she could see them face to face, and she declined it. So lately, she hasn't been in our visit since November 19th of 2024. All her visits have been Zoom.
That
So
was
we
Miss
have
W's
tried.
fault though, and I just had to work.
Okay. Yeah, Miss Young, we're giving your lawyer a chance to cross-examine, okay?
And the reason why the visits were by Zoom, she didn't let me finish, was because of her work hours. But we were still going to bring the kids to her either on her lunch hour, for her to see her kids face to face. We would have picked them up from the grandmother and took them where she works. But also, Miss Young is not upfront with her job either, because we found out just recently she worked at Walgreens, which months ago she told us she worked at McDonald's.
Okay. So it's not uncommon though for people to change jobs, right?
Yes.
Okay. So putting the job issue aside, what would be the harm for the children at this time, and why the suspension of visits would be necessary?
Because Miss Young is not upfront with her mental health. She has, if you look at the paperwork that we gave months ago at All Well-Being, she was diagnosed, and she has not followed through.
Okay, I'm going to object, Your Honor. May I?
Go ahead.
All right, we've heard that exact answer. It has no bearing on whether you suspend visits. We know that people cannot always comply with all their treatment plan. There's nothing in writing from a psychologist or expert indicating the risk of harm in the visit. This issue is a non-issue. I'd ask that you rule on that issue now. Thank you.
Well, at this point, Mr. Brand, I think the department has the right to ask those questions. I'm well aware of what the standard is for me to suspend visitation, and that it can't just be used as some sort of a punishment or a carrot and a stick to get a parent.
Well, I think y'all coming down on me too hard. Think about everybody else around us.
Miss Young, please. So, Mr. Brand, your objection's noted for the record, but I'd like to hear what has to get said here because, and again, Mr. Densimo's client is the one they're trying to get the visits from, although that would probably residually affect your client as well. you'll have right of cross-examination as well, but I'd like to hear what is going on and all the nuances here. So
I understand.
noted, overruled. Thank you. Go ahead, Mr.
The only reason I objected because the answer was identical. And if I get a third answer the same way, I'll object again.
Okay, go ahead, Mr. Dragon.
So but you'd still be looking to keep the permanency plan as reunification with parents?
Yes, but I would just need her to be more open and upfront with her mental health and continue to get back into her services. And I get it that people don't have to do their services, but what she was diagnosed with, we need her to be in her services so that we can move the visits outside of our agency to maybe day visits, eventually going to overnights and weekends.
Right, but she hasn't even had visits at the facility or since at your agency since November, you said?
November 19th was the last time our agency, because of her work schedule, they've been vivid Zoom.
All right, has there been, when was the last attempt at working around Ms. Young's work schedule to allow for visits at the agency?
Ms. Young says she works to 8 o'clock. We don't work, and then she's worked on the weekends, and we don't work weekends. So,
right.
like I said,
so she works Monday through Friday until 8 o'clock?
That's what was told to us from her.
Okay. I have no further questions.
Thank you. Miss Springs, any questions?
Yes. Ms. Williams, are the visits harmful to the children that the mother's having now by Zoom or by phone?
Yeah, because she do ask, sometimes she can be inappropriate for the visits. And we don't have to redirect her as to asking where they are, what's going on, personal stuff was dealing with in the grandmother's home. And we have to redirect her and tell her that's
I think that answer is very inappropriate from an outside point of view. I'm their mother. I'm going to ask them personal questions to see how they're doing.
Ms. Williams, please. I don't want to have to mute you or exclude you from the hearing, so please. There's an order and a process to this. I ask that you respect that, okay, ma'am?
And to continue, Ms. Springs, if it's something more in details, I didn't do a lot of the visits, so Ms. Dawkins is the one that did the majority of them. But when I say asking, like asking where dad is at, things of that nature, where's Miss Williams' husband, or who you out with?
She's lying.
Take you such a place.
Oh Lord, these people be lying.
But some of the things she answered, I feel is inappropriate.
Okay, but you're lying.
That's Miss Williams' house.
To say inappropriate.
Ask about school, how they're doing, what's going on with their lives Monday through Friday or weekend.
What?
Ask more personal.
What?
With the people that's in the household.
They're around my kids.
Your knowledge, does the mother, Ms. Young, does she become argumentative with her girls during visits?
Yes, that has happened. And they get frustrated. They have left to want to leave the visits because she don't hold a conversation with them.
These people are bold-faced lying.
She's very outspoken. And she would tell her, okay, what you want to talk about or what you need.
Okay, it's getting there now, though. It's getting there now, though.
You know what? Excuse me. I don't want to go down to every single visit where everything was said inappropriately. The question's kind of a more broad generalization. Outside of being able to say this.
Do they just believe anything that they say?
She said that at one particular thing. In an overall general picture, what harm is going to the children if mother visits in these controlled settings?
And what truth is she going to tell?
Control setting where we supervising it. Okay, we can supervise and redirect her.
Redirect who?
Inappropriate. Outside, I think
that's very inappropriate.
It may be inappropriate because I don't know how.
Okay, well, what's your understanding of what mother's visits are right now?
They're Zoom visits, whereas she would ask them questions, about everybody else.
No. What is your understanding of the legal status of mother's visitation.
When you say legal status, I don't understand the question.
What are you legally allowed to do in terms of her visits? What visits you want to suspend them? What does the court order say that they are currently at? What do you have the authority to allow visit wise?
Well, right
What
now
type
we
of
just allow her to do the Zoom because that's all she can.
What type of statement was that?
Objection,
Well-
that's not responsive to the court's question.
Yeah,
You've asked
direct.
3 times now.
He's
Never
directing
mind.
her and she directed him.
I'd ask to strike
Ms.
this
Springs,
witness's
go ahead.
testimony. It's
Your Honor,
not relevant.
let me say this, please. I have spoken to these children. I've spoken to these girls quite a bit because I'm constantly on the phone with
Can you
them.
interrupt, Your
with
Honor?
the
This is
workers.
this is our.
And I'll address my.
Hang on. Ms. Springs, there's been an objection. Mr. Densimo.
Your Honor, this is argument. This is inappropriate. Ms. Springs has the right to cross-examine this witness. She does not have the right to make a legal argument at this point. If she wants to cross-examine the witness, obviously I've tried not to interrupt.
If I could finish, I don't need to be interrupted by people who think they know the law better than me. Okay,
Excuse me, Ms.
I don't
Springs.
need that. I'm
Ms.
sorry,
Springs.
I don't.
Ms.
That's
Springs.
an attack on.
I don't have another question, Your Honor. I'll make a statement because I've spoken to my client.
Then save it for a statement, and please hold your comments about other lawyers to yourself.
Thank you. I'll do that if they'll do that.
Well, his was a legitimate objection that you were making an argument, and you weren't the witness. Because if you're going to testify, the witness's presence becomes superfluous. So, that having been said, Mr. Brand, do you have any questions?
One question. When
Yeah.
is the last date, time, and place that you saw the father, or talked to him, or Zoomed him, or FaceTimed him, or anything?
I think the last time they did their parenting visit was December 31st from what Ms. Dawkins have on her report.
They're never going to tell the
I don't know if you've seen them.
truth.
Most of
I
the
don't
time,
even believe the
his
words that
visits
come
are
out of their
supervised with Ms.
mouth.
Williams,
What's the point?
or in the relative's home. She does keep in
I
contact
can't even
with them,
believe they just even lie in
regarding his
court, though.
employment and the services
She's under
that
oath.
he's participating in.
Very good. I move to strike the entire answer. I did not ask anything but the date, time, place that she saw him or communicated with him. Her. That's Miss April Williams from Christ Child House.
Thank you, Mr. Brand. All right, your objection on that is noted. And in terms, I'll take that testimony for what it's worth. When we come to arguing, you can argue it then. Thank you. Mr. Densimo, you have questions of the witness, sir?
Can you hear me? Ms. Williams, can you hear me?
Yes, I can.
Ms. Williams, you did not write this report, did you?
No.
Mr. Dawkins authored this report, didn't she?
Ms. Dawkins wrote the report. That's correct.
Were you aware that on October 2nd of 2024, All Wellbeing submitted a letter indicating that Leela Young had received services at All Wellbeing from the dates of April 11th, 2022 through July 12th of 2023, and again on August 10th through 2023 through August 30th of 2024? Were you aware of that?
I thought I might have seen it, but I'm not aware. I would have to look that up in our files.
Isn't it a part of your file?
It is a part of our files, but I don't have that in front of me.
Didn't you send this information to me?
I might have sent it to you.
Yeah, they
on
did.
behalf
They
of
sent it
Ms.
to me. They forwarded it to
Dawkins.
me.
Were you aware that All Wellbeing said that during this time, Ms. Young had the capacity to receive case management, psychiatric, nursing, and individual therapy services? Were you aware of that?
If needed.
Yes.
Were you also aware that All Wellbeing said Ms. Young has engaged with All Wellbeing monthly from April 11th, 2022 through April 24th of 2023? Were you aware of that?
I wasn't aware of that from 2023.
And were you aware that All Wellbeing said that during this time she engaged in the above services appropriately? Were you aware of that?
I thought it ended in 2024 of July.
Were you aware that that All Well-Being said Ms. Young completed a re-engagement intake on August 10th of 2023, and she engaged monthly from August 10th, 2023 through November 4th, 2023, and again from January 6th of 2024 through June 15th of 2024. Were you aware of that?
Yes, I was aware of that.
So in all, Ms. Young was in therapy with All Well-Being for nearly 2 years. Is that correct?
That's correct, from the date you gave.
And isn't that a significant period of time to be in therapy?
Yes, it is.
And is that consistent with your request that Ms. Young engaged in therapy?
Yes, but after June
No, I asked
2020.
you, is it
Ooh-wee.
consistent with your
Yes.
request that she engaged
Ooh-wee.
in therapy?
Yes.
And she engaged in therapy for well over 2 years.
Yes.
Isn't it also true that Ms. Young completed a parenting class?
Yes.
And she completed that class in February 20th of 2024?
Yes.
Is that correct?
Yes.
And in fact, you sent me, at my request, about 92 pages of documents from All Well-Being covering the course of Ms. Young's therapy. Is that correct?
I don't remember how many pages.
Did you ever submit those documents to the court?
Yes, all those documents Ms. Dawkins submitted.
Did you ever give those documents to Attorney Springs?
Ms. Dawkins might have forwarded them to her. If we forward them to the court.
Then can you explain to me why Attorney Springs felt the need then to subpoena those documents if she had already been provided the documents?
Objection to that question. Objection to that question. Speculation on the part of the Ms. Williams wouldn't know why
she had him
Ms. Parsons
the whole time.
Why would Ms. Springs need to subpoena documents if Ms. Dawkins had already provided them to her?
I would not know why Ms. Springs needed to do it. Only thing I know is we forwarded them to the courts, all of those documents.
And those documents should have gone to the children's guardian ad litem, shouldn't they?
Yes, they should have went to everyone.
Ms. Young, you've seen the records that Ms. Young has employment. Is that correct?
I have seen her badge that you just forwarded to us.
Did you see her pay stub that I sent to you?
I didn't see the pay stub.
Were you aware that I sent her pay stub to Ms. Dawkins?
Ms. Dawkins brought that to my attention, but I didn't see it myself.
So shouldn't Ms. Dawkins be testifying here today?
Yes, but she had an emergency, so she wasn't available.
So Ms. Dawkins is aware of information regarding Ms. Young, positive information regarding Ms. Young that you're unaware of.
When it comes to the pay stubs, yes.
Were you aware that I sent an email to Ms. Dawkins indicating that I had personally gone to Ms. Young's job and verified that she worked there? Did she tell you about that email?
Yes, she told me that.
Did she indicate to you that in that email I saw Ms. Dawkins, that I verified that I saw Ms. Young use her employee pass key to enter?
Objection. Now counsel is testifying. He's testifying.
I'm asking about an
Swear
email.
him in. Please swear him in.
Ms. Springs, I'm going to let it go. Thank you.
Were you aware that I sent an email indicating what I saw when I visited Ms. Young at her employment?
Objection. What kind of question is this?
It's a question about why something that he provided information to a worker is not in the report, and that worker is not here. So he's asking the worker we do have.
I'm present.
Any reason why that wasn't included?
I'm here. Everything is complete on my end.
Not you, Ms. Young. We're talking about someone else. Not you, Ms. Young.
Thanks, Ms. Young. Go ahead, Mr. Densimo.
To answer your question, she sent me the email that stated that you saw her use her pass key to her employment. Yes, I did see that email.
Do you have any reports where you've ever reported to Referee McGuire that Ms. Young had completed two years of therapy sessions?
I would probably have to pull the file. I don't have them personally on me.
Wow, you're unprepared.
The past 3 reports that Ms. Dawkins had submitted, none of them contained that information, did they?
I couldn't answer
They
that because I don't
hid
know
hid
if
all
she
the
sent it
credit
or
that I
not.
obtained
You
over
are a
time.
supervisor, correct?
Yes,
They
but
are
I
my
You
was
review her
children.
documents, don't you?
Yes, I do. I review her court report and what's in there, but I know from her last one, it was
They
a
lied in
very
that too.
thick one because it had the CPS report and some other documents attached to it.
In the
I
last
can't tell you
report,
everything that was attached.
has Referee McGuire ever been advised that Ms. Young has been in therapy for 2 years?
I
I don't know the
can't.
objection is the
And it's
relevance
day
because I don't
4. They keep
understand.
trying to get me to go
We're
to
talking, I think, the dates that Mr. Consimo gave, correct me if I'm wrong, were pre-adjudication. Mother
The
was
most current,
adjudicated.
I'll withdraw that question, Your Honor, and ask another question. In the most current reports regarding the dispositional review hearing, is there any indication at all that Ms. Young had completed 2 years of therapy?
Not in this report, is not.
And there wasn't any in the previous
Add
report
it.
before this one, was there?
Bring it
I
up
would
to
have to
date.
look at that report to answer that question.
Don't you review these reports before the
Yes,
hearings?
but you're talking about 3 months ago. That I would have to see that report to see what she put in there. I don't have that in front of me.
Actually, I think we were in court 1 month ago, and there was a
month
report
ago,
authored.
I don't remember that a month ago.
They're unprepared.
So let's review. Ms. Young has full-time employment. Is that correct?
That's not our
From what was
problem.
reported, yes.
That was a requirement in the treatment plan. Is that right?
Yes.
Ms. Young has housing, does she not?
Yes.
That was in the treatment plan. Is that correct?
Yes.
Ms. Young has completed therapy sessions. That was in the treatment plan too. Isn't that correct?
Yes.
And Ms. Young has visited her children. Isn't that correct?
Yes.
Ms. Young hasn't engaged in any criminal activity that you're aware of, has she?
Not when I'm not aware of, no.
And you have no reports that she's engaged in any kind of antisocial criminal activity, have you?
No.
In the report, Ms. Dawkins indicates that the children are having behavioral issues because of the separation from their mother. Did you read that in her reports?
Yes.
And the children are having to have, they have been placed in therapy as a result of these separation issues. Is that right?
They've been in therapy since the case opened.
Is it true that Ms. Dawkins in her reports indicates that as a result of the separation of the children from their mother, they have begun to engage in inappropriate conduct?
Yes.
So continued separation appears to be harmful to these children. Would you agree with that?
I would agree.
I have no additional questions, Your Honor.
Thank you, Mr. A.
No further questions.
Thank you. Mr. A, call your next witness, sir.
I have none.
Thank you, Ms. Springs. Any additional evidence or witnesses?
Yes, the mother, Leila Young, please.
Ms. Young, could you raise your right hand and be sworn, please? Do you swear or affirm under the penalty of perjury the testimony you are about to give before this court will be the truth?
Yes.
Thank you. Go ahead, Ms.
Your Honor, I do have a question. I apologize for my lack of knowledge as to this area, but can Ms. Young not testify if she elects not to?
No, this is a civil
Alrighty.
proceeding, so thank you. But in these proceedings, hearsay, and in these proceedings, at a DRH, hearsay and everything else is admissible, so you'll have full right of cross-examination, Mr. Densimo. Go ahead, Ms. Springs.
Ma'am, would you state your full name, please, for the court and for the record again?
Leila Young, the mother of Liberty and Lauren.
And Ms. Young, there's a question about whether or not you received, well, let me ask you this. Are you aware your children were adjudicated temporary court boards, I think back in September of 2024?
Someone had called making allegations, and they had said that they needed to remove the children temporarily for 30 days to place them outside of the home to make sure that they are safe.
Miss Young, Miss Young, I don't want the whole explanation of all that before. Just see if you can limit to the question that was answered. Ms. Springs, could you repeat the question?
I'll rephrase. Ms. Young, were you aware that the court conducted a trial regarding a petition that was filed against you alleging abuse and neglect of your children?
Yes.
And you were present for those proceedings, is that correct?
Back in 2013, yes, I was present.
Not in 2013, in 2024.
I'm sorry, 2023.
Your children were adjudicated as made temporary court wards by this court in 2024. Is that correct?
I was not aware of that, no.
September, I believe, of 2024?
I was not aware, no. I was told they were temporarily placed at Mrs.
So
Williams.
you were not aware that your...
No, I was not aware.
You were not aware that you were represented at that time by a different attorney?
I believe...
At that time, you were represented by a different attorney, is that correct?
Yeah. But I don't remember them making my children wards of...
Okay. Let me ask you, Ms. Young, then, as a foundation, what do you think the nature of these proceedings are?
Reunification.
What do you think these proceedings
returning my children back
before the court?
Returning my children back, because I do have custody of them, and I have not had my rights terminated, and I am the mother, and I have been present at every single hearing, doing my part as they have asked, so that they can return home. And what would be the I don't see another solution.
Thank you, Ms. Young.
Ms. Young, were you offered a treatment plan after your children were made temporary court wards?
I never knew they were made temporary court wards. I was only told that they were being temporarily placed at...
Hey, just, all right, Ms. Young, we can go back and forth about what you understood on that day, but you were present. I'm looking at my court order now. You were present on the day of trial. You had full opportunity to participate in the trial, and whether you know what the technical term for it was after that, your children were made temporary court wards on that day, and we moved to a disposition to put a service plan in place. So that's the status. Ms. Springs, please move on.
Pursuant to what the court has indicated, Ms. Young, you were given a service plan with certain conditions you had to meet for the reunification that you just spoke about, correct?
Okay.
Is that a yes or no? Were you given a service plan?
Yes.
Okay. And what were the terms and conditions of that service plan?
They asked me to follow up with all well-being, so that I'm not sad or upset because my children are not at home, and just so that I can have somebody to talk to about my issues and problems that I was having while they were gone and out of my care temporarily. And they also wanted me to continue with my employment, and they also wanted me to complete a parenting class while they did an investigation to make sure that everything around us was safe.
You left out the part about your mental health. What was required for you to do regarding your mental health?
That's exactly what I just said. They wanted me to follow up with.
Excuse me.
Miss Young, your lawyer is talking. Yes, Mr.
I said I object. The witness answered Miss Attorney Springs' question when she said that she was engaged in therapy, and that was a part of the treatment plan.
Well, the part of the treatment plan said she was to have a psychological evaluation and follow that. I guess my question goes back to that even been referred.
Well, Your Honor, I guess the professional persons who are servicing can answer that question, but I have another question prior to them giving you that answer.
Well, Ask mother about what she knows, and don't ask her to speculate on things. Go ahead.
Ms. Young, did you sign the treatment plan?
No, I did not sign a treatment plan, but I did complete it.
You have refused to sign the treatment plan, is that correct?
I didn't refuse, I just haven't. But I did complete it.
And why haven't you signed the treatment plan?
Because I don't give my consent for something that I don't agree with. By law, I don't.
All right. And it's true that prior to the petition that was filed before this court and prior to adjudication, you did have some treatment at Our Wellbeing, is that correct?
I did follow up with the counselor just as the kids had counseling as well during our separation period.
And you have reviewed the documentation from All Wellbeing. Haven't you reviewed it? Have you reviewed it with your counsel?
When I spoke with them, they have to give a diagnosis for billing purposes. I never pay attention to the diagnosis.
And what was the diagnosis you didn't pay attention to?
Whatever you guys were speaking of, I had no idea of. I just went to counseling to talk about my problems.
When you went to All Wellbeing, did All Wellbeing give you a diagnosis?
I'm not sure.
Okay. What were your problems at All Wellbeing? What did you disclose to them were your problems?
I was just talking to them about things that were personal to me that I don't care to talk about in front of the court.
Did you do a psychological evaluation?
In the beginning. After that, I just followed up with treatment and went to counseling as needed, not as a requirement.
And what year was that?
You guys continued to force me to go, so I just continued going. That was back in 2022.
Okay, well, thank you.
In 2022?
Yep.
And 2022 was prior to the filing of a petition, is that correct?
It was not a filing of a petition. Someone made a false rumor.
No. See, Miss Young, that wasn't the question. The petition was filed. The court takes judicial notice that the petition was filed in 2023. Go ahead.
Oh, okay, for this, yeah.
So, did you follow up since the adjudication of your children as temporary court wards? Did you follow up with a psychiatric evaluation?
That wasn't a requirement.
Did you follow up with a psychological evaluation?
I had already had an evaluation during in the beginning when I started receiving when I started going there. I didn't need to have another one. They didn't require me to have another. They just.
Did you review the document? Did you review the pages and pages and pages of documents from All Wellbeing Services regarding your treatment or your visits to the All Wellbeing?
I've heard a lot of different sides of different stories, but like I said, you guys continue to try to force me to go there, and I just went to counseling. I didn't really look into all the stuff that I can't, get. People are gonna make up stories. That's not why I'm here, though. I'm here to get my kids back.
And in the course of All Wellbeing Services, did you demand that All Wellbeing simply send a letter to the court saying there was nothing wrong with you?
I don't understand your question.
Let me ask you, Ms. Young, are you on your phone? Are you on a phone in front of you?
No.
Okay. Do you understand that I'm asking you about what did you request from All Well-Being when you were treated there, when you went there? What did you ask them to do for you?
As far as like why I would be attending All Well-Being,
Did you demand All Well-Being send a letter to the court for you?
At some point I did ask them to make a letter so that I can give it to the court. Yes.
And did you repeatedly tell All Well-Being staff that there was nothing the matter with you, is I believe the term you used?
No, we were just always like talk about personal stuff, like different things that I would, be we would talk about, all types of things, but I don't care to talk about it in court because that's what I talk about with my counselor. You guys told me to go to counseling, and that's what I did. I don't need to come here and have counseling and then tell you guys what I was counseled about. But like I said, mental health does not mean unfit parent.
Ms. Young, when you visit your girls, you are very argumentative with them about what they say or don't say about you. Is that correct?
I'm not a perfect parent. I don't know what you're insinuating.
How often do you visit with your children by Zoom?
Every week on Tuesdays at 5:45.
Okay. And during those visits, you accuse the children of lying on you about why they came into care. Is that correct?
I was a little concerned about that because I didn't know that they had. Yeah, that was my first time hearing them mention that. And I was a little upset because as a mother, it is my duty to make sure that my children are well taken care of. And if they're making up stories like that and they're telling people stuff like that, then I'm going to be concerned.
Miss Young, it was a yes or no question. Did you accuse the children of lying on you when you heard during a visit? Yes or no?
Did we have a conversation when we talked last week? Yes, we did. We talked about what they were saying.
No, that wasn't what I asked. At some point during some visit, did you accuse the children of lying about?
I didn't accuse them of anything. No, I didn't accuse them of anything. I just was wondering why.
When you ask, did you say that's not true or you're lying or something to that effect?
No.
Okay, thank you. Go ahead, Ms. Springs, move on.
Okay. Ms. Young, are you able to hear me clearly?
Mm-hmm.
Okay. When you visit with Liberty and Lauren, did you tell them that their grandmother was just keeping them to get a check?
Well, I was concerned about them being approved for a check because.
Yes or no, please?
No.
I'll take. Well, you see, here's the problem, Ms. Young. When you're asked a question and you start explaining why you did that, and then go, "No, I didn't do that." Those are two conflicting answers. So
well, it's there's an explanation. There's not just a yes or no. There's an explanation. And I haven't got.
It was a yes or no question, no. Well, it was a yes or no question. So
there's so much other stuff that needs to be explained that is not being explained, and I haven't had the opportunity to say anything.
Can I object to the question? I don't see the relevance of the question at this point.
Well, in as much as there's a motion to suspend mother's visitation, and the standard for that is that the children are being harmed, and there's great latitude allowed in these dispositional review hearings, I'm going to let it go, but obviously, Mr. Densimo, you have the right to cross-examine, and I'll entertain anything, in argument after that. Thank you. Go ahead, Ms. Springs. Well, you know, Ms. Springs, let's try not to bog down on one particular incident at one particular time kind of stuff, because we're trying to look at a bigger picture here, and we can go through almost anybody's visits with a fine-tooth comb and find something where something was uncomfortable or didn't go right. So let's see if we can get more bigger picture things.
Ms. Young, do you believe you have a mental health issue?
Yes, Your Honor, it's irrelevant what Ms. Young believes.
It's not irrelevant, Your Honor. The pages and pages of work of evidence from.
I'm not. You know what? Considering what's said in the report, I'm going to let her answer the question. Thank you. Go ahead.
No.
And therefore, you have not pursued the need for medication.
It wasn't a requirement.
Objection, Your Honor. There is no evidence that Ms. Young needs to be medicated.
I am going to sustain that objection. Strike that question.
Ms. Young, are you receiving information from your attorney about how to answer these questions?
That, Your Honor, I told my client, I sent my client an email saying to answer Ms. Springs' questions professionally, politely, and give her a straight answer.
Thank you. Go ahead, Ms. Springs, move on.
Well, Your Honor, I have nothing further. I have argument.
Thank you. Mr. Ahee, any cross-examination?
No.
Mr. Brand, any cross-examination?
No, it would be irrelevant to question I would ask, so I'll withhold it.
Thank you. Mr. Densimo, cross-examination, sir?
Ms. Young, you're employed full-time, are you not?
I am.
Ms. Young, can you hear me? Ms. Young, can you hear me?
Yes.
You are employed full-time, is that correct?
Yes.
Okay, you are responsible for all of the expenses in your household, is that correct?
Yes.
You own your own vehicle, is that correct?
Yes.
You have been involved in therapy at All Wellbeing for, were involved in therapy at All Wellbeing for over 2 years, were you not?
I was.
And during that time in therapy, you covered a number of issues, personal issues, is that right?
Yeah. I guess. Yeah.
Are you, Ms. Young?
I mean, I would.
You were in therapy with a therapist for a very long time, weren't you?
Yes. Mm-hmm.
And you sought that out voluntarily, didn't you?
I feel like I was forced to.
Well, not voluntarily, but you found the facility yourself, didn't you?
Yeah.
At the beginning of all of this, you did sign a treatment plan, didn't you, Ms. Young?
Yeah, but it's outdated. It expired.
Yeah. The answer to my question, you signed a treatment plan at the beginning of all of this, correct?
Mm-hmm. Yes.
And after you had done a lot of work in this case, the agency came to you with a second treatment plan, another treatment plan, is that right?
Yes.
And your lawyer advised you not to sign that treatment plan, is that right?
Yes.
And that is because you and your attorney felt that you had substantially complied with the first treatment plan, is that right?
Objection to the form of that question.
Completed.
Objection.
Speculation. It's speculation because Mr. Densimo was not her attorney at that time.
That's why he's asking.
The attorney didn't testify.
The question was, what did her and her attorney determine? So I'm going to let it go.
So to repeat, upon advice of counsel, you elected not to sign that second treatment plan, is that correct?
Yes.
And that is because you had substantially complied with the first treatment plan. Is that right?
Objection.
Completed.
Objection. That's a leading question.
That's
cross examination, Ms. Springs. He's allowed to lead. Go ahead, Mr. D'Ensimo.
And in the first treatment plan, they asked you to obtain full-time employment, didn't they?
Yes.
And you obtained full-time employment, didn't you?
Yes.
In the first treatment plan, they wanted you to go to therapy, didn't they?
Yes.
And you went to therapy, didn't you?
Correct.
In the first treatment plan, they wanted you to obtain suitable housing. Is that right?
Correct.
And you had suitable housing, didn't you?
Correct.
In the first treatment plan, they wanted you to visit with your daughters. Is that right?
Yes.
Your Honor, I object to this for lack of foundation. I think Mr. D'Ensimo is talking about a treatment plan that was in the Washtenaw County Probate Court, not this court. There's only one treatment plan.
He's talking about a prior treatment plan, but I think that becomes relevant as to what we've done in this case here in Wayne County so far. So I'm going to let it go. Thank you.
And I do believe, Your Honor, this is a treatment plan. I do believe this is a treatment plan that came from Christ Child, and there was another previous worker on this case. But again, the treatment plan, you complied, Ms. Young, you complied with virtually every condition in that treatment plan, didn't you?
Well, can you repeat your question?
Ms. Young, said you complied with the portion of the treatment plan that required you to get housing, correct?
Correct.
Can you hear me, Ms. Young?
Yep, completed.
Ms. Young, can you hear me?
Yes, I completed that.
Listen, Ms. Young, can you hear me?
Yeah.
Okay, and you obtained suitable housing, correct?
Yes.
Yes?
Correct.
And you went to therapy. You went to therapy, correct?
We're just repeating that. This is all asked and answered.
Correct.
Mr. D'Ensimo?
Right.
I'm going to concede, the report indicates that mom does have housing. That mom does have, from the testimony today, mom does have.
What is suitable housing?
Yeah, Mr. D'Ensimo?
Lastly, you completed a parenting class, is that right?
Yes.
You have done a lot of work to get your daughter.
I'm going to cut you off right there. The little light indicating you were speaking was on, but I couldn't hear anything for a while. So you might need to restart that last question over again.
All right. You completed parenting classes, is that right?
Yes.
Just to wrap this up, you were in therapy in 2024, isn't that correct?
Yes.
And this case began in 2023, I believe in April 2023, is that right?
Yes.
Well, the court can take judicial notice of when the case started. I don't have any additional questions, Your Honor.
Ms. Springs, any redirect?
Yeah, Ms. Young, where are you at the moment? Where are you testifying from?
I'm at home.
Okay. Thank you. I have nothing else, Your Honor.
I have a question based on that.
Mr. Amy, go ahead.
Ms. Young, if you're at home right now, don't you typically work at this time?
Yes.
Okay, so did you take the day off?
Yes.
All right, you took the entire day off to attend this hearing at 1:30?
Yes.
Okay, nothing further.
Thank you. Mr. Brand, any recross?
After much contemplation about the testimony that you heard and the relevancy thereof, I have nothing that could add anything else to inform this court. Thank you.
Mr. D'Ensimo, any redirect exam? Or pardon me, it would be recross at this point. Again, the light's on, but I couldn't hear you, Mr. Densimo.
I just said, no, I do not have any additional questions.
Thank you. Ms. Springs, any additional evidence or witnesses?
No, Your Honor. Thank you.
Thank you. Mr. Brand, any witnesses or evidence?
No.
Thank you. Mr. Densimo, any additional evidence or witnesses?
No additional evidence or witnesses. Judge, I'm just interested in knowing, I filed a motion to terminate temporary wardship, and I submitted some documents as exhibits. I was just wondering if the court had received that motion with those exhibits.
I have not. I have not received it.
He's
And if we could take a short break and I could see all the lawyers in chambers for a second.
The recording has stopped.
Closing arguments from council, please, Mr. Aiken.
Your Honor, I do ask the court to adopt the recommendation to continue all prior orders and services in this matter. With regards to the visitation, considering that mom's visitation has only been via Zoom since November, I would ask for the court to continue the visits as agency supervised or even in therapeutic setting. I don't believe that there's enough to suspend the visitation, especially when we are still considering reunification as the ultimate goal.
Thank you. Ms. Springs?
Your Honor, I would concur with the request that you change the order for the mother's visits to be agency supervised or in a therapeutic setting, SETTING. I have spoken to the children and they have expressed that they do not like the visits with their mother. They do not like the questioning and the accusations. I'll just say it that way so that I'm not accused of testifying, even though these are my clients and I am their guardian ad litem and their attorney. I would ask that you change the visits to those two settings as set forth by the Assistant Attorney General in his argument. I'd ask that you order the mother services to continue, including that mom get a psychological evaluation, which she has not done, and that's for the well-being of the children in light of the original petition that's before this court. Thank you.
Thank you, Mr. Brand.
I ask that you order a worker to meet with my client and go over the treatment plan, follow the law, and I'm sure there's a new parent agency agreement treatment plan that should be signed and prepared for him. Page 4 is inadequate in its description of services for my client. It does not go through the whole treatment plan. It's 64 words long. It doesn't detail anything. I'd like to see more information in regards to it. My client, Mr. Davis, in page 5 in the recommendations section, there is absolutely no mention of Robert Davis. It is as if he does not exist to the writers of this report. Supervisor who signed it as well. Thank you.
Thank you. And Mr. D'Antimo? Did we lose? No, there he is.
And if I knew how to ask you not to fund this case and take him and make the county pay for it, I forgot the language that I should say. I would say it.
It's in all of my orders that services all be provided at department expense.
Yeah.
So,
I like your orders. They're great orders.
Your Honor, I previously filed a motion to terminate temporary wardship. I'd like to renew that motion orally. In that motion, I indicated all of the things that have been argued and that we presented here today. We presented unrebutted testimony that Ms. Young has full-time employment, she has suitable housing, she's completed parenting classes, and she's undergone 2 years of therapy. All of those things were demanded in the parent agency treatment plan that she originally signed with the treatment agency. There's nothing left for Ms. Young to do. I understand that there is some concern about her mental health, but there is no record that Ms. Young is suffering from a mental illness such that she needs to be medicated or that she needs ongoing mental health treatment. It's been a year and a half since the origin of this petition. Ms. Young, since that time, Your Honor, has worked full-time, maintained a household, pay her own bills. She's taking care of herself. She's not engaged in any antisocial conduct whatsoever over the past year and a half that this case has been ongoing. There's no evidence that Ms. Young is currently suffering under the disability of a mental illness to the extent that she cannot properly function or properly care for her children. Given that Ms. Young has fully complied with the treatment plans that were set before her. That there's very little there's nothing really that she can do to prove herself to the court. She has shown the court that she is making every effort to reunite with her children, and that she will do whatever it takes in order to reunite with her children. We ask that Ms. Young be reunited with her children today, immediately, that the temporary wardship be dismissed in this case, and that Ms. Young's children be returned to her. I'm not going to take up everyone's time, but she's done everything that she was supposed to do. She's done everything that was required of her, and we have submitted proof of that, Your Honor. We've submitted documentation that she's done everything that was required in order for her to have her children returned, and she deserves to have her children returned today. So we would ask the court to terminate temporary wardship and order that Ms. Young's children be returned to her immediately.
Thank you, Mr. Avey.
Well, just a few things. As I would easily concede, mom has completed parenting classes, mom has housing, mom has employment. However, as this court knows, that was never one of the primary issues for why these children came into care. And while mom may have completed therapy services in the past, the fact still remains that these children came into care in 2023 because of mental health issues. And mom didn't receive her treatment plan. The court didn't adjudicate on this case and these children until September of 2024. So there's been nothing on the record that mom has been actively participating with her mental health treatment or even completed a psychological evaluation as has been court ordered. So once again, the largest barriers that remain are the psychological evaluation and the mental health treatment. Thank you.
Thank you. This case does present some interesting questions because there seems to be a divide between the testimony that we have on the record here and some of the things that are in the report. But one of the things I do notice is that there is testimony on the record that mother completed parenting classes in February of 2024, that mother has full-time employment, that she has housing. She's not been involved in any criminal activity, and mostly that she has a car, but that she was in 2 years of therapy before this. Now, one of the allegations in the petition were that mother had unresolved mental health issues, and there was some physical abuse over discipline of the children. The logical, or at least the connection they were making, that one has something to do with the other, and that's not an illogical conclusion. However, what I'm going to say is this. We can quibble about all of the other things that mother may or may not have completed at this point. It appears she's completed a number of them that the department has not documented or doesn't seem to be aware of. But the one thing that I don't have that was ordered specifically on September 11th by this court was mother is to have a psychological evaluation and follow all recommendations. Now, that psychological evaluation, if mother had done that and it had come back and said she's already completed, she was medically discharged from all wellness services, great. But what I'm saying is this, is that Ms. Young needs to at least participate in some of this to give me the information I need to be able to say, okay.
I've completed that.
Okay, and Ms. Young, that's what I'm saying though, is that like Mr. D'Ensimo elicited testimony that you were in care with all wellness and so on. I need to get something from that therapist.
He been submitted all of that. We came prepared.
I know he did. But I need
time and time again.
But ma'am, Ms. Young, I ordered a psychological evaluation.
You guys are trying to hold my kids from me.
No, I'm trying to find out if it's safe to return them to you.
But somebody called and lied, and I did what you guys asked of me. Not because not because it was true, but because I needed to prove that I was being truthful.
Right, well, and Ms.
You're treating me like a victim, and I'm not the victim.
Well, the problem, Ms. Young, is no, we're not treating you like a victim. And that's the thing, is I'm not treating you like a victim. And what I'm trying to do is tell you this, is that my goal, my job and my here is to reunite families. But I also have a charge, and I've taken a note that says I cannot do that unless certain legal requirements are met that make me feel certain that the children are not at risk of harm. I ordered a psychological evaluation. Don't view me as the enemy. That's what I'm going to tell you right now, because I'm not asking for this so I can get something on you and try to hold it against you. I'm asking for this so that I can get a clear picture of what's best for all parties involved. That means you and your children, so that I can reunite you as a family sooner rather than later. That's all I'm asking of you at this point. The other stuff that's been ordered, it looks to me like Mr. Densimo has done all of his homework and got that.
I have as well.
Mr. Densimo, I did not get the written motion. If you want to file a written motion, include those as exhibits. We can notice it up on a particular date, or we can put it up on the next hearing even. But on the bigger picture, the court does find that there were reasonable efforts made to try to finalize the court-approved permanency plan. All prior orders will be continued except as modified here, and that includes the one that says mother is to have a psychological evaluation. And
Sir, I had it.
Well, and then if that's why I want this one, to confirm that whatever documentation
There was nothing in the other one to make you think that I needed another.
From Team Wellness, ma'am, you need to provide whatever you had from Team Wellness. You need to provide to our clinic, but I need something from our clinic.
We provided everything. The CPS worker did, my attorney did, I did. You guys didn't follow up with your paperwork?
Well, I'm not the one who follows up on that. So
we came prepared.
Now I want to follow up on. Okay, I'm saying I want to follow up on now. All right, Mr. Ahey, the request by your department to suspend visitation is denied. Visitation is not to be used as punishment for somebody not complying. And again, there's conflicting evidence about the children and their views of the visitation, what goes on. So I'm going to continue all prior orders. I want mother referred for that psychological evaluation. And Miss Young, your cooperation in this is necessary. And
excuse me. This has been going on for 3 years now. There's no cooperating at that point. I'm frustrated. My kids are gone.
And ma'am, like I've told you, I have certain legal things I have to.
But you asked me to do things that I've done, and then you're trying to throw something else at me as if I haven't already completed everything to get my kids back. And now you're trying to tell me that I didn't do what you asked of me to get them back, as if I knew this the whole time so that I could be prepared for today so that I can receive them on Valentine's Day. I mean, why would I even need to wait another time? That is so unfair.
Court continues all prior orders except as modified here today. The next review of this matter will be.
60 days, 90.
Give us 60.
Wednesday, April 16th at 9:30.
Counselors, April 16th at 9:30 a.m.
Your Honor, logistically, does mother get this evaluation at the court's clinic or at a place of her choosing, or please, for the record?
No, this was ordered to be done from our clinic. Mother has indicated to me that she has documentation from another clinic. She needs to provide that to them so that I can get the bigger picture, because to sit here and say, I've got this documentation from one place, so why should I go to yours? But I need to have that, and I don't have it yet. So, and I still would like to hear from our clinic, because other clinics that people have done are sometimes for different reasons or searching for different answers or whatever. I'd like to compare and contrast the two if I have them, but I want to know what is going on and where we are with this, because the reports I'm getting and the testimony that's been adduced here, There's a huge chasm between the two of them. And I want to narrow that. I want to find out what it is, and I want to be informed about it all. We'll see everybody back here April 16th at 9:30 a.m. Those are the recommendations I intend to make to a judge of this court. If any party disagrees, you have 7 days to seek review before a judge of this court, or 21 from the Michigan Court of Appeals. There's nothing else. Hearing's concluded. Parties are thanked and excused. We're off the record. Thank you.
The recording has stopped.